handout today from the PTO that explains what those things are. We can dig into that in a little bit. And then the specific music involvement in that usually focuses mostly on copyright, but we also do a lot of contracts and some trademark stuff too in that context. So we'll explain a bit about how that all works and what we do and how we try to help people. My own practice, I represent mostly what we refer to as the artist or creative side. Artists, songwriters, performers, producers, a smaller amount representing more the industry side, which is labels, publishers, managers, things like that. So not exclusively one or the other, but I have more experience working directly with the people who are making, writing, playing the music than the people who are usually bigger companies that are operating some of those other sides of the business. So, Carol, I'll let Carol talk a little bit about her background in this area.
Yep, so I'm practicing for about 2 years now, right at 2 years. I started out mainly business real estate, and then our other colleague Pete, who's also an IP attorney, does film and TV, and he brought me in. And so that's when I got to learn a lot about, I had a little bit of background in trademarks, but that's when I learned a lot more about just general contracts and what all goes into like film and TV deals, and then also a lot of copyright stuff. And then Gary joined not too long ago, and that kind of got me integrated into the music stuff because I do love music so much. And I realized that it's definitely a different ball game, but kind of a little bit of the same roles. So it's been good to learn. And I really like it. So I'm glad that we get to kind of discuss it with you guys today.
Yeah, Kara's a big music fan and actually a little bit of a music influencer too. So she won't brag on herself. No.
I have a Spotify playlist. I think that's why Gary let me start working with him. So I was like, oh, the Spotify plays a lot of likes. He's like, that's so cool. You should start doing music stuff. So never thought that would be a segue into widening my career.
That's why I like it, because it's genuine, your interest and your knowledge and things. So,
You cover poetry.
I don't have a lot of experience with poetry, but I consider songs to be poems for sure. And the same principles in terms of copyright principles apply to those as to any other written work like that. So indirectly, absolutely. I don't have a lot of experience in the business around poetry for sure, but we can definitely explain the concepts and how they apply. So one thing that I'd really like to do, and I should have done sooner, is have you all talk to us a little bit about who you are and why you're here and what you hope to learn around the music business or copyright or whatever else. It may not be what you all hope to learn tonight, but what do you want to learn in the industry generally and the practice in general. So if you don't mind, I'd love to hear from all of you, and maybe you ask the first question. I'll let you start with the introductions too. Is that okay?
Okay, my name is Teresia Simmons, and I am a poet. I have 3 volumes of poems that I have published. I do have a website. I have performed locally, and I performed in front of the St. Louis Symphony Orchestra twice. And I performed at my church and everything too. And I started writing in 1982. It was the cathartic way to do with my divorce because it was working. And so I started writing, and then I took care of my husband for really, he was diagnosed in 2010 with dementia and 2012, but I knew he had it in 2010, and he passed in 2019. So I talk about my journey through all that. And it's just really talking about life experience rather than loss and, anger and all of that too. So it's been well received. So I want to find out, again, even though I'm published, how do I copyright it so they can't take it? Because I've had that happen already. And do we go to the Library of Congress also? So those are some questions that I have. How do I protect my work?
Great. Well, thanks for telling us about what you do and your journey. Thank you for being here. You want to pick it up from there?
Sure. My name's Mike, recording artist, recording engineer. Recently found the flyer for all the, free events that were going on this month in honor of the 50 years of hip hop. So I've been taking advantage of those free tools and, just here to pick up on anything that I can learn for free. So I'm all about free education.
Great. Well, you're right that this is one event, and we'll highlight some others at the end if we don't get to it sooner. Maybe want to share some of those things that other things that are going on. That'd be great. Yeah. All right. You're next, I think.
My name is David, and I am a DJ and a recording artist. And I kind of wanted to learn about how to protect my work, but at the same time not take anyone else's work, because I believe in, sampling and, kind of taking pieces of stuff that's already out, but I kind of want to do it in a way where I'm not disrespecting anyone or taking anyone's work.
Yeah. Great. So those are good things to be, good goals to have learning wise, I think. So. All right.
Okay, my name is Jeremiah Dyson, and what I am is I play many instruments. My life revolves around music. I'm a multi-instrumentalist. I play 10 instruments, and I do a little bit of producing a little bit. So I want to pick up feedback on what he said. I want to learn how to protect my work and how to steal anybody else's respect.
Yeah,
that's really what I'm doing.
What's your name again?
Jeremiah.
Jeremiah. If I say it. Oh. Yeah, Michael, David, Teresia, right? Yeah,
Okay, my name is Mike Dyson, not Tyson. It's spelled online. It's spelled MYK Dyson. That's my artist name. They call it so many things, but I'm a holy hip hop / R&B gospel recording artist. I've been doing this for a little over 20 years. Actually, I've been, supporting people up to 15 years into now. So 5 years to now, I've been doing my artistry work. Basically, I come here because I want to understand what I've done and make sure I've done right with putting my songs out. I went to copyright.gov and I went to unpublished works. And I want to make sure that was the right thing to do. And at the same time, I want to learn how to copyright my words and everything, you know what I'm saying? So I want to get deeper into it for real. I guess somebody told me about ASCAP and BMI and pretty much how you can get paid for all of the stuff you do instead of just some of it. So,
yeah,
I'm curious about that.
Good. Yeah, that's good. You're good. I think the good news is at least some of the things that you guys want to know, we're already planning on talking. So we probably won't get to all of it, but it's a tip of the iceberg kind of situation. You only see, there are things that you don't see, but you don't know how much of it you're not seeing. So you start to see a little bit more, and that'll lead you to more questions. We answered all those questions, not all those questions, it's more like body of knowledge, right? But if we were able to give you that right away, you'd have more. There'd be other things that you don't know yet. But so I think it's really important to have kind of a mindset of building your set of tools to educate yourself and to learn. And I don't mean that because I don't want you to be clients of a lawyer, ours or otherwise, for your whole careers. But I want my clients to be people who are constantly learning about not just their craft, but their business. If you're going to do this as a business, you don't have to do it as a business. You can just do it as a craft, as an art form. There's nothing wrong with that. And some people choose that. But if you want to do it as a business and you want to have it be your career, then you need to know some of the business elements of it. And the business elements are all based on the laws around it. There's a lot more to it than just the laws, but they're based on that. So I want people to be building up the resources that they have to learn. Hey, I got a new question today. What are the ways that I know? Where do I go to find answers to those things? So we want to be part of that, but also point you to other things that are part of that. Well, that's great. Well, let me give a little bit of an introduction. Do this kind of overview thing, right? So as a way of starting, one of the things that you have in your hand, this pamphlet, is from one of the resources that I want you guys all to become familiar with, the United States Patent and Trademark Office. That is a branch of the government, a branch of the Commerce Department that does the administrative process around the patent and trademark side of intellectual property. There's another, I actually do have for myself a handout from the Copyright Office, but it's long and I didn't make copies of 10-page thing for all of you when you can just read it online anyway. I got old and look at things on paper, but I figure you're giving you 1 page is one thing, but 10 is probably throw it away. But and you don't need to print it out to get the information from it. But so the Patent and Trademark Office and the Library of or the Copyright Office, which is a little bit confusingly organized under the Library of Congress, are really good resources for information. This copyright one that I'm going to talk about and this one that we handed you all come from those 2 websites. There's a lot of other information on there too, but this is a good starting point. So right already, we haven't even talked about anything substantive. I've given you 2 resources: Patent and Trademark Office, Copyright Office. Those are places that you can go and read things and learn about things and get examples and get help. There's FAQs, there's videos. PTO has a goofy trademark news series of videos.
Right.
I've seen those that are like, they're also pretty cringy and funny, but they are educational.
Helpful.
They teach you stuff. So, so those are good things. But as an overview of intellectual property, okay, you talk about patent, trademark, and copyright as the 3 main areas of intellectual property. And a lot of people don't know this, but I think it's kind of a fun fact that the patent and copyright side of that kind of 3-sided intellectual property category actually comes from a very old place. Anybody know where that might be?
Constitution.
Absolutely. The
Retired
Constitution.
teacher.
Article 1, Section 8, Clause 8 of the Constitution is often referred to as the Patent and Copyright Clause, and it says Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors that go along with science and useful arts the exclusive right to their respective writings and discoveries. So those are referring to the 2 categories of things that we now call patents, copyrights. That's where that comes from. And this existed in other countries at the time the Constitution was written. So it wasn't just a philosophical idea that was thrown in there. A lot of our copyright law comes from English copyright law, like a lot of our other laws do. But that's where that came from. So I always think it's important when you're thinking about these things, like where did it start? Well, it started there. Like that phrase in the Constitution empowered Congress to then go and write the specific laws that we call the patent laws and the copyright laws that are the details around what's going to be protected, how is it protected, how do you get it, how do you extend it, how much does it cost to protect it, stuff like that. So, but that's where it comes from. So, and then, so patents cover inventions. So it's a way, has to be a novel, useful invention. And if you prove to the patent office that it is those things, you can get a patent. Patent only lasts for a certain number of years, like 17 years, I think. Yeah, we're not patent lawyers, but no, that's but you have to go through that process, and you don't have the patent protection, which means you are the exclusive owner of it, until the patent office says, yeah, you got it, here you go. You have to prove it to them. Copyright's a little bit different, but it protects the expression of ideas, not an idea itself. The expression, it's the way an idea is expressed. And that can be all the things we talked about, you all talked about, can be poetry, it can be a film, it can be a script for a film, it can be a painting, it could be song lyrics, it could be recorded music. Those are all different categories of things that in the Copyright Act, it says this is one of the things that we, Congress, have decided to protect under this clause that the Constitution says we can do. So if it's in that statute, then it's subject to copyright protection. The copyright protection is a little bit more automatic in that as soon as something is created that falls into one of those categories, the copyright protection attaches to it. You don't have to convince the Copyright Office to give you anything. It exists when it exists. Like when you're born, you're born. Like when did you start being born? When you were born, right? Like that. Now you're born, right? Same with copyright, or same with a copyright protected work. So that's what it is. Now, you already mentioned this, but there is a registration process with the copyrights. That is a way of, we'll get into the details of it, but it's a way of formalizing and protecting what you already have as the author. It exists when it exists. The copyright registration is an enhancement and a protection of that.
I like to think of it as almost like a notice to everyone else
Yeah.
that you are the owner of that. Like you are no matter what, as Gary said, but that is just putting it out there, documented on paper that you are the owner.
And the copyright practice in particular has evolved and changed a lot over the history of the country. At least in the US, I don't know as much about international copyright, but so there were times when it was more formalized, that you had to do certain things in order to keep that copyright stuff. And that causes a lot of confusion. People think like, well, I didn't do this thing and I heard that you have to do that one thing in order to have copyrights. It's just part of the history, but it exists when it exists. When you write a song, when you write a poem, when you take a video on your phone and like do some crazy, angles and like make some 30-second clip or whatever it is, that exists now. You've captured it, you put it in a form, a tangible though digital form. It exists. The copyright attaches to it immediately. What you do with Copyright Office is just taking it an extra step. So that's good. And then, so we covered, I did in reverse order almost, trademark, patent, copyright. We still have to talk about trademark a little bit, just as an overview. Do you want to just kind of give like the basic of what trademark is?
So first of all, I see on here that they have an IP identifier, which I think is really helpful, because that's one of the main questions I always get is like, what do I have here? Is it a trademark? Is it a copyright?
Yeah.
This is the first time I'm seeing that, so I just wanted to point out that resource. But when I think of a trademark, I think of a brand. So what does it say here? A word, phrase, or design or combination. Basically, it distinguishes your goods or services from everyone else. So like when you see the yellow M, you know that it's McDonald's. When you see like Kleenex, you know that it's going to be tissues, but a little bit, it's kind of different than copyright, whereas you have to earn like the distinctiveness for it to have rights. You don't have to register it with the trademark office. So what you'll have is something called common law rights, which just means if someone comes after you, you could say, well, I've been using it and like customers have come to identify my business or goods or services in the world. So you would still have like an upper leg with them. However, if they had registered before you, registering is kind of like the golden, like, if you really want protection in your copyright, registering is going to give you the most like highest rights in the mark. So you can do, what is this? You can do a phrase, design, or a word. So that's a lot of people will do even a design in conjunction with a phrase or all three.
I just remember what,
Go ahead.
thing I was gonna do with the record.
Oh,
Because
okay.
it always has a label, like it has.
Right,
has a brand
right.
on the back.
Right.
So I was gonna. We've done this before and I brought records to shows like visual aids to talk about different things. And I forgot to do that tonight, so I was gonna borrow something out there, but they didn't know. There's like someone's private collection or something, so they didn't want me to steal the records, which is fair. That might be accused of doing that. But that's the thing that's not even, so to kind of apply this to the music business, like where do all these things fit in? If you flip over a record, it's gonna have the name of the company that printed this, whether it's one person, it's that company, or Universal, which is a multi-billion-dollar global company. It's gonna have a brand on there. So that's gonna be on there. But what people sometimes don't think about, that as an artist, your name of your artist name is also a brand. The most important phrase in here in terms of music is indicates the source of your goods and services on that paragraph. It tells people who it's coming from. Who's the song from? It's from, what's your artist name? Mike Dyson. Mike Dyson. This song came from Mike Dyson. How do I know that? Because he told me, you got his name on it. Like that's a brand, that's a trademark. Like that's your name, right? That's your artist name. So if it indicates the source of where it's coming from, that's a trademark. And you wanna think about that too. And it's also the same thing that you guys pointed out about talking about defensively. You wanna make sure you're not infringing somebody else's in the trademark world too. That's also important. So I like that you guys are thinking about that. So now we've built the structure, right? Patent, trademark, copyright, like those are things that we talked about. before we kind of, obviously, we're gonna go more on the copyright side, because that's what we're here for, right? Oh, wait, are there people online? I didn't make them introduce themselves. That's probably hard, that's okay.
Yeah.
I just didn't want to forget that there might be more. Okay. But if they have questions or whatever, you know.
Yes.
let me know too. What questions do you guys have about this overview that we've given you so far? Anything that makes sense?
I guess. Question is, as far as copyrighting your music, would you prefer? As an artist, when I put a song out, that I copyright everything separately, like the words and the music. Cause some, you know, most of the stuff now I produce myself, but the thing about it, sometimes I might get something from someone else and I'll put their name on it when I do distro kits or whatever. But the thing about it is like, do you prefer me to copyright my words and then also the song, also the music?
I mean,
Separately
by
or together?
prefer, do you mean, like, I can say that more about what you mean by.
Okay, well, I say this, am I covered? Cause I, like I said, I went to Unpublished, called Unpublished Works.
Gotcha.
And so I went and did that, is my whole song and my words and everything is it covered? If I did it that way, or should I separate them and cover them separately?
You know, I think organizationally, it might be easier if you had separate, because you might, the reason to have a registration is if you ever have to enforce it against someone. So if you have them as separate pieces, there might be some situation where there's an infringement of one part of it, but not the other. It might be the identical words, but the music's totally, the recording is totally different. Okay, do you know what I mean? So you, but what
I
I,
feel like that one kind of segues into
the two
yeah,
things.
the
yeah.
main point
Yeah.
of kind of,
Yeah.
what we want to talk about.
Yeah, like what are the different things when you even talk about registering it all together? What is that, right?
Yeah.
So, but I mean, the fact that you're doing anything is good. Like what I would prefer is you do something, you know, but that's always better than not taking any of that stuff. I wouldn't let it be a barrier to other things that you need to do to be successful as an artist, to register every little piece of everything separately. Just like I wouldn't say, you know, well, don't perform a show until you have a good account. I mean, get better at doing shows so you need the account. I prefer you put your energy in that way first. Now, it'd be great if you had a great account to help you with everything and make sure everybody got paid the right amount, make sure you got paid the right amount, did your taxes. That's all good too, but you gotta get the other stuff going first, you know? So that's, I think, it's a little bit of a general answer. I'm not answering you, but I'm not giving you an exact answer either, but, you know, yeah. Well, we can get into a little bit more of what those things are in terms of. Other questions or things I've said that don't make sense?
I'm just thinking about, was it Bruno Mars that got sued for, was it, I think that one sentence or one phrase that sounded like Marvin Gaye's
Yeah.
music?
That was,
Yeah, not Bruno Mars.
what's his name?
No.
What's
His
his
father
name?
played.
His father played on that.
Probably.
Oh.
It was who?
Probably.
Robin.
Robin Thicke, yeah, Robin, yeah, exactly.
Yeah.
Robin, it was, oh my goodness. But I know what it was.
Smooth lines.
Oh, blurred lines.
Blurred
Blurred lines, there you go.
Yeah.
Yeah, that was Marvin Gaye's actually beating everything he had.
Yeah, very simple.
He just took it.
I mean, well, I don't know, I guess he did.
Ooh.
Well, they were found,
Yeah.
they were found to have infringed it. I don't know if that was ever appealed. You know, but.
Cause I actually, one thing I did learn, and like I said, when I hear from you guys is, when you, like, I'm dealing with this company called DistroKid, so. When you're dealing with them, they say that you have to go get some kind of form, talk to the people or whatever, and then get them to approve it before you can come out with a parody or even a cover.
Yes.
For the song or whatever, before you can do it, so I thought about that.
Yeah, so let's add other questions for, I mean, we can talk about the case too, but in the context of pulling this apart. So I think a really good place to start in terms of copyright and music is, what are the two things that are covered by copyright? So the most important thing, like, I'm so sick of me saying this, but what do I always say? Like,
It's like a bundle of sticks.
bundle of sticks. And each one of those sticks has is a different type of right. So you have to figure out what work you have. And then you can figure out which sticks are in your bundle. So there's two types of works that are specifically set out in the copyright that apply to the music business: musical compositions and sound recordings. The most important thing in so many aspects of this business is that you stop and you slow down and you think about, wait a second, am I talking about a musical composition or am I talking about a sound recording? I had a conversation today with a person who has been working in not just music, but like dance performance, 50 years. And I was explaining, well, what you're thinking of is musical composition. This is a sound recording. You understand what the difference is? And she did, or they did, but it was like, wait, back up, hold on, what are we talking about here? Because until you do that every time, you're going, I'm sure I've said that before. What are you talking about? Musical composition or sound recording? What is it? And why does that matter? You gotta figure that out. So, let's start right there. What is it? What is a musical composition? It's the music, meaning the melody, harmony, words that are in the song that you write. That's the best way to think of it. It's literally the melody and the lyrics are the
Think of like an old piano book that has the lyrics with the keys on it, like that is the composition.
that's the musical composition. It's not any particular recording or performance or version of that. It's the words of the music. Right. So that is a musical composition. And then there's a bundle of sticks that attaches to that musical composition. We're gonna like kind of go through this chart, talk about what some of those are. But what they're not is sound recordings. That's a different category of work. Those are defined terms in the Copyright Act: musical composition, sound recording, and they mean different things. Sound recording is the fixing of that musical composition into a certain type of a recording. It's right there in the name, a sound recording. So it's taking that composition and then recording it in some form. You now have two different works, two different copyrights: the musical composition and the sound recording, and different rights attached to either of those.
Sound recording could also be the public performance of it, correct?
Right, so each of public performance is one of the exclusive rights that attaches to some, but not all, copyright protected works. For compositions, there's an exclusive right to perform the composition publicly attaches to the author of the musical composition. They own that from its onset, from the beginning of its existence. Sound recordings don't have that. It's just not one of the sticks that they define in the Copyright Act. There is no public performance for sound recording, except, because we always make it complicated, in the digital world. So there's digital sound recording, but not digital, not the real world. So if we're in an auditorium and over the loud system, over the speaker system, I push play and allow to be performed a song, a musical composition that's fixed as a sound recording, I need the permission of the author of the musical composition to do that, to play that. That is a public performance. It's one of the things that you can do with a copyrighted work. I don't need the permission of the sound recording owner because there's no public performance right that attaches to that work. So you can see how we're automatically getting into this, like, well, if I don't know which one I'm talking about, there's no way I'm gonna know which right attached. You gotta figure that out first. And sometimes it's harder than it seems. Like, wait, am I talking about publishing here or am I talking about sound recording? Right? So that's the process that you go through each time. So the other thing that we should have said about copyright law at the beginning, all of these rights that we're going to talk to in every situation except when there's it's being created by an employee of a company, and then that's that employee's job to create those things. The person who owns the copyright is the creator themselves. So with music, we're talking about the composer, the lyricist, the person who wrote the melody or lyrics or whatever part of the composition it is. That sometimes there's more than one, but it's always that author. They own it from its existence. The only time that's not true is if you're an employee of someone else and it's your job to write songs, then the employer owns it. Or if we have an agreement before you even wrote it, we wrote that agreement down, signed it, virtually or otherwise, then if we did that before you actually did the writing, then I could own it if that's what our contract says. Other than that, the default is the author owns it always. So that composer, that lyricist, you know, who your poet, you're the author, and so you own all these rights. In the sound recording context, it's a little harder to figure out who the author is sometimes, because is it that person just turning the knobs and like pushing the buttons in the control room of the studio, if you're in a studio? Is it the person performing, you know, playing the guitar, playing the piano, you know, doing the mixing? Is that the author? And sometimes it's all of those things. So it can be a little bit harder just to know, but the answer is it's whoever is doing the creating. So you have to know who's doing the creating. So what that means is when you're doing the creating, if you're doing it with other people, how do you know who's doing the creating? The easiest way is to all talk about it and agree. We're all doing the creating here, or I'm doing the creating and you're not, right? We're all on the same page with that? Like,
Like, I'm doing 20%, this guy's doing
Yes.
20%, and you just put it on like a napkin.
Yeah.
That's the like worst case.
if
scenario.
that's what you need to do, that's what you need to do. We might be able to figure it out from the facts, like, we might come in after the fact and be able to learn enough about what the circumstances were. But we'll know for sure if you wrote it down, and then when you talked about it, that's the way to know. So, you know, it's fun to get into this, like, well, was that flute player that was, you know, were they really adding enough to this performance to be an author also? They might claim that they were, you don't know, but if you talk about it ahead of time, you say, hey, I'm gonna pay you $150 to play the flute for 5 minutes, you're not gonna be an author, you're agreeing with me ahead of time, right? We're all on the same page here, you're not writing this, you're not creating this, you're playing this, performing. So that's what you wanna do ahead of time, because otherwise, everybody involved in the creative process. Now, in film and TV world, this is a nightmare, because you know how many people on a TV set could potentially be.
And the person
authors?
walking by, that's like,
Yeah, say it with more inflection.
Yeah.
Now am I an author because I helped create the end product?
right,
You need everybody in that room to have agreed, yeah, I'm doing this work for hire, you own this, I'm just getting paid here. That's what you want. Now, I'm describing the perfect situation, life is not like that, it's just not. You want it to be as much like that as you can. And each situation, try to make it more like that. But it's this ideal world, you talk about all that stuff, and you decide it neatly ahead of time, and there's a scribe taking notes. Okay, well, that's not real, that's not realistic really, but get as close to that.
I'm saying, reason why I'm saying, because actually, you came with something that made sense, like, Copyright.gov came back at me, because I got 2 songs with featured artists. So, my son's on one, and then I have another artist on another one. Since I put it on DistroKid like that and split it up, they came back at me and said, hey, are these 2 people, you know what I'm saying, they compose their work, they write their own words and everything, and I was like, I had to say, yeah, like, they did, well, you didn't put that on Copyright.gov, so. They came back at me, yeah.
Yeah,
right.
but then you learn that, right?
Yeah,
Doing
yeah.
better.
Exactly.
Is anyone allowed to change any part of your work, like, once it is written down?
What type of work are we talking about?
Sometimes like your poetry.
So so it depends what the context of the changing is, like change it and publish it, change it and use it in a different format. That's really, you know, we don't really have a way of policing whether I in my office, you know, change some of your words. But it's really when I try to do something that commercializes that would be when that would kick in.
For example, was, I wrote a poem for our founders person, and the poem was too long. So they changed it, shortened it, so it would fit into the book. And told me after the fact.
So did you have an agreement with them for the publishing of that?
I told them they could publish it, yes, but they weren't supposed to change it.
Yeah.
If there were any changes, that was up to me to make.
Yeah. So I think it's interesting when you're talking about just taking things away, right?
Mhm.
Because it's that you gave them permission to make copies of it, like that's the copyright on it. That's what that is, it's a copy, it's a reproduction. publishing and printing or digitally printing or whatever they did. But I don't, we don't usually think of subtraction as, it's usually addition or change too, right? So that's what's interesting about it. I don't know if it really would be copyright infringement because it just took away from, but it certainly was, you have a contract with them, you have an agreement with them, might not have written, you have an agreement with what they can do, and that's really what they violated. Now, you have to think about what is the value of how you were harmed and working, but it's probably really based on the agreement you have, more so than the copyright that's not that. That's certainly more true than if they had made changes and moved sentences around and then even worse, not credited you or something. That would be a copyright infringement as well. So it's probably more in the nature of a contract that was not followed or breached, as we say on that. Does that make sense? Yeah. Okay, so let's go a little bit further through this kind of list of what's the difference between a musical composition and sound recording. So we've talked about what it is. We've talked about who the author is. Musical composition is going to be that composer, that lyricist. Sound recording is a little more complicated. We got a producer, we got a performer, we got a sound engineer, maybe. We're much more likely to have a situation where you have joint authors, more than one author. And that's a really important time to have something in writing. We call them split sheets in studios about who was on both the musical composition side and the sound recording side. Who owns what parts? How much percent? What are we agreeing on? Are we 50-50? Are we 10-10-10-10-10-10? Do I get, 3% because I said 3 words at one point in the middle of the afternoon of the session? Like, how are we going to do this? Like, we want to have that documented as best we can. So that's that. So that's what it is because the author. Just talking a little bit about, I think I said before, copyright exists as soon as it's fixed in a form the work is fixed in a form you can point to, touch, see, hear, handle. So that in the musical composition can be a lot of different things. It can be sung into a phone. It's now fixed, and you also have a sound recording of it as well. It can be written down on a piece of paper, the words and notes, and the chords, maybe sheet music, like you're talking about the pianos. That's the fixation. The term for the fixation in the sound recording world is usually called a phonorecord, and then kind of copyrights. Like that's what the Copyright Act means. But phonorecord doesn't just mean those things that they would want to bring in here, like the vinyl records. It means any sound format that captures that sound. So you have digital phonorecords, MP3, wave. I mean, all those things are phonorecords. It's been fixed in that digital tangible form, as well as a CD or vinyl record, a cassette. If you're into that. That can work too. You'd be surprised. I've seen more cassettes in the last 5 years sold than the 25 before. So that's what it is. That's who owns it. That's who the author is who owns it. And those are examples of how it's fixed. So we should talk a little bit more about what some of those specific sticks we talked about in the bundle are. Give you some examples of that. The one that is every form of copyright, every work that's covered in the Copyright Act is going to have some stick that refers to being able to make a copy of it or not. So you have the exclusive right to make a copy or reproduce in the words of the Copyright Act. That's going to apply to everything. So sound recording, the author has the exclusive right to reproduce a sound recording. Musical composition, the author has the exclusive right to reproduce, make a copy of the musical composition. It's going to be the case with everything. Again, the hard part is sometimes figuring out which one you're making a copy of, but you're probably making a copy of one of those in any kind of commercial usage or exploitation of the work. When a poem is published in a newspaper or a blog or magazine, they've made copies of it digitally or physically. So those are reproductions. Something that is a good little wrinkle to introduce is the concept of derivative work. A derivative work is a second work that you made from the first work. So a sound recording is a derivative work of a musical composition every time. Because before you can sing it into your phone or play it in the studio or whatever, there had to be a musical composition. It might not be written down yet, but it's there, and then the sound recording becomes the derivative work of that. So the author of any right to which the derivative work attaches has the exclusive right to make derivative works. So that means in order to make a sound recording, who has the right to make a sound recording? That's a derivative work. So the author of the musical composition has that. So when you make a sound recording from a musical composition, you need permission of whoever owns the sound, the musical composition to make that derivative work. Now, this is where we start to get like, why did they do this in the music business? There's a massive, massive, massive exception to that. Have any of you ever heard a cover song? If that's a recording, you've got a derivative work. You have an exception in the Copyright Act for that particular example of derivative work. Once a song has been published, anybody in the country, anywhere, can do another cover of that song. It's called compulsory license. It's in the statute that you have to grant those licenses. Now, they still have to be paid. The original owner has to be paid. The composition owner has to be paid, but you can't deny them the right to make the derivative work in that situation. Question?
Can you receive it?
Absolutely, but not from the publisher, not from the composition, because you don't own the composition, right? You own the sound recording, the derivative work that you own is the sound recording of the composition. Okay. So the owner of the composition gets the income from your use of his or her composition, right? You can still receive the income from the sound. Okay. Does that make sense? So that was a long way of saying yes, but not really.
So if they use, like you said, they use the authors and like in a movie or something like that, they use their composition in a movie or something like that. They get paid for it, but it's off us. You said if we're using it as an artist, they get paid from us too. So we gotta decide what they get paid, or they gotta.
So actually, like using it in
No, that's the other part of that, yeah.
Using it in a movie is a good example of another stick that's in that bundle. The exclusive right to make synchronizations.
Yeah.
Synchronization is the Copyright Act term for setting music to video or even still footage, photographs. So if you're syncing the music to that's an exclusive right that's owned by that attaches to both the publishing and the sound recording. That stick is in both bundles, right? So you have the author has the exclusive right to do that. So if you make a cover of somebody else's song utilizing the compulsory license, you pay them the fee. The fee is determined, it's set out in statute how the fee is determined. You pay that fee, then you own the sound recording of their composition. You own that cover, right? If somebody then wants to make a synchronization of it and put it in a film or a TV show, then they need the permission of both the composition owner and the sound recording owner. They gotta have both of you.
Oh, wow.
And if they don't get both, they can't use it. You can't use the sound recording without also at the same time simultaneously using the composition. So you need both. So we spend a lot of energy in the music business on synchronizations and getting the licenses for both of those. So it's a really important concept. It's a really important source of income as well for artists and for writers. But it's a very complicated and heavily related process. Actually, it's more administrative than like question.
Okay, so say if you wanted to use like only the vocals or only the instrumental of that music, would you have to get permission from both with that too? Is that right?
What do you mean by only the vocals or only the?
Like you may want to use the vocals, like I don't know, like what situation you use the song.
So like,
Probably for a song or like for a video or something like that, like as a reference or something like that. And you might just want to use the vocals for that, or you want to use the instrumental just like.
So are you talking about taking the recording of the vocals or the instrumentals, or just having some like re-recording the vocals?
Oh, no, like so, like taking the vocals.
Like if they had acapella version, like
from the sound recording.
if they you could buy an acapella version or something like that, or instrumental.
Yeah, so if you're using the recording of either the vocals or any one of the instruments or any part of the track, if it's actually the recording, then you're using the composition at the same time.
True.
Because it's all there. So if you re-recorded it or re-performed it, replayed it, whatever, like kind of like, you know, made it again, like then you're just making a new cover that you then own the sound recording, somebody else still owns the composition, and you would only have to use the composition. So like if you sampling, it, like let's say you take a sample, you take one of those records out there, and you take a 3-second piece that you like, and you put that into your Pro Tools or your Logic or whatever you use. I can't remember what the other one. And then you've taken part of the sound recording and the composition that sound recording is made from. You're using both of those, so you need to clear both of those. You need permission for both writers.
Okay, so while we on this part, real quick. I heard it's probably not true, that you can use like less than 4 measures and be okay. I'm just saying. So that's not true. Somebody told me
There's no number of measures,
Okay,
there's no number of
gotcha.
beats, there's no
Okay.
number of words, there's no number of seconds,
Yeah.
there's no number of what else.
Yeah,
Like,
anything.
And they-
And that doesn't mean that every unit of those things is going to be, that if you take even the shortest one, that there's still,
It's still,
there's still defenses, but it is copyrighted. If it's really small, something called de minimis, it's not really worth worrying about. There's something called fair use, but like, there are some circuits.
It's
in
still,
particular
like,
that-
Imperishable, you
Yeah.
would get for 2 measures, you would get that cleared.
yeah.
Yeah,
I was having a conversation again today. I didn't think about these things. I guess I actually talk about this stuff all day. don't I was in a conversation with a publisher today about a situation that's 5 notes.
Yeah.
And if I sung the 5 notes right now, you know songs.
Oh my God.
And I'm a bad singer. Like if I played them with the right instrument, you definitely.
Yeah.
So I know they're short. So there's no amount, there's no just number of bars or number of beats or measures, notes, seconds, nothing. That you can be sure is not copyrighted.
Right.
There is sometimes a situation where we're not gonna consider this one copyright infringement because it's 4 notes that nobody would ever recognize or comment. Yeah, okay, but there's no bright line with that.
I figured that.
If there was, we probably wouldn't be sitting here, so it'd probably be a
Yeah,
lot
I mean,
more simple. But-
I had a friend who told me honestly, he's like, no, dude, no.
Yeah.
He's like, you ready to get sued? No.
Yeah.
Good friend.
Yeah, I can't know. I ain't gonna know either.
That's excellent. I have a question. So if we want to put music to my recording, what we're doing was putting my works on Kindle. So if he wanted to put music with my poetry, we would have to get permission from the artist.
Right, well, from whoever owns that musical composition and that sound recording. Because if it's music that's in a sound recording, it's both. You got a musical composition and a sound recording there. So you would need to get permission from both of them.
This is what I was worried. He's a professional. So I'm like,
there are other resources, they may have got the music from pre-cleared
Yeah.
places, so
Yeah.
they may have got it from somewhere that you just buy it, and then it's like, you buy the license too, so you're not actually reaching out to the owner, because they've already sold it to this,
Library.
yeah,
Yeah.
like wherever, so that when you pay them, the money ends up going to them.
The-
So like, just because they didn't directly talk to the owner doesn't mean they didn't get it cleared, but you gotta get it cleared from somewhere.
Yeah.
I'm sure he knows what to do. That's cool.
Those are the questions you wanna ask, right?
Yeah.
Where do we get the permission to do? Right. You don't have to use all the content, like, be like, just ask like what it means. And how do we know we have the permission to do?
I'm just crazy now for being hurt, so.
Yeah. Yeah. And positive conversation there. Like, we're good. We're moving along now. So we talked about a bunch of these exclusive rights. Distribution is another one that's in the potential bundle of rights there, the right to distribute copies or phono records, whether these are composition or sound recording. That's something that also applies to the original. The author owns that exclusive right too. You can, and that can be, distributions can be by a lot of different, I mean, you mentioned one of the most common, DistroKid, that's the distribution. You are the author, you have the exclusive right to tell DistroKid they can do this. Like, you're giving that right, you have it, you can give them permission, you can pass it on to them. That's what they're making you sign off on all those checklist forms.
Yeah.
Yeah.
I'll check one.
Yeah, yeah, absolutely. I guess we already talked about performance, like performing it publicly, that applies to the author, that attaches to the author of the musical compositions. It does only in the digital world for sound recording, so there's no general public performance right in sound recording. So, do you guys have questions around what public performance is?
Well, what are? If I
This is
talk,
something I actually just learned last week, the full scope of it from Barry.
So, so
Go
to
ahead.
publicly perform the work means a lot more than it kind of just implies. It's actually any way that that work is played in a public place. If we're sitting here today and music was on a recorded, stereo system that we were playing music through, that's a public performance. If I'm playing my guitar, which you would not want to hear, and singing, which you also would not want to hear, that also is a public performance of the musical composition. Both of those things are public performances, even though they have kind of a very different feel, what they are. The music on the background, background in the store when you're shopping.
He told me elevator music, that's a musical performance, and that's when I was like, oh, okay, that makes sense out of how more vast it is.
Yeah, that's a public performance too. Play it on the radio is a public performance. Play it on television is a public performance. So from the stadiums, played live to the smallest venue, all public performance of the musical composition. It's not talking about sound recording. That's
another question. How do you copyright your photographs? Again, I had another incident where I went to an Apple store and I was just showing my beautiful photos. He wanted to see something. And he actually took my picture that I'd taken and put it on his phone without my permission. He'd already done it. Bloop, there it was. Right. So can't do that, right?
I don't know how that works technologically. Well, so photographs are similar in that they are the copyright and which bundle of sticks. We won't get into all the different bundles of photographs. It's very different from music, but there is also a bundle of sticks, bundle of rights that attaches to every photograph as of one of the protected works under the Copyright Act. And you have to go through the same process of what that does that apply here? And reproduction or copying is definitely one, that the author of the photograph owns that first. So they give it away to somebody else, they own it. So when someone takes a copy of a photograph, if it's not done with permission, then yeah, that's copyright infringement. They made a copy of it. If they also distributed it, they made it as another form of infringement, because the author has the exclusive right to distribute it. So all those same things apply in terms of how you would protect it. Again, it exists when it exists, and then how you would enforce that right or enhance that right by filing a registration made is a different question. But it exists when it exists, and the rights attach as soon as it exists. So now what you do about that and how you're damaged, and that's a different practical question, right? But yes, it is copyright infringement. Someone took a photo and made a copy of it, they made a reproduction of it with where it is. That's copyright. Probably need to have good photographs. So oh gosh, this is like a long guy. Okay, well, I think we kind of got through the main categories of what rights attach and to the different two main types of work. I don't know what other questions you guys have just based on that, but anything you can think of, I'm happy to at least pretend to be able to give you an answer.
Yes. Oh, I'm sorry.
Oh, I'm sorry, you both have hands. Go ahead. We'll come to you next time.
Oh, So back to my previous question when I asked, if I can, still get monetized for recovery not use, how would you determine how much you get from your voice rather than from the original composition?
So you're talking about if you take a vocal part from a sound recording.
No, I mean,
No,
like,
he's saying
if I,
he performs a cover.
Oh,
He
if you
makes a
perform the
cover.
cover. So there's a statutory rate that you would pay to the owner of the musical composition. Or you can work out an agreement with them directly for a different rate if you can do that. But there is a formal statutory process that you can go through and just pay that rate. It's pretty kind of administratively cumbersome. So most of the time, it is just an agreement kind of directly between the parties. But there is a process that you can do that can follow the statutory procedure. You have to give notice and calculate what the rate is, and you have to count them and stuff like that. You have to tell them how many copies you sold or what income you made for it and stuff like that. Okay. You can get those licenses through, it's called a mechanical license that you can get. And that's the compulsory license that you can get because the work has been published. You can follow that process and you get that. So, that's a whole thing to dig into, but that's like what you want to look at. Michael.
As far as getting permission for composers, how would you find out who the composer is and how do you go about contacting?
You want to take that one?
There you go.
I'll try my best. So he kind of mentioned it a little bit earlier, PROs, which there's ASCAP, CSAC, and
BMI.
BMI. And I know I'm missing others.
GNR, but those
GNR.
are the four main.
Those are the main ones, and so it's basically an internet database. You can go in and search these. What is the one that called that has both of them in there?
BMI has
BMI, yeah.
and ASCAP both have listings for both, but
Right,
it's a little
so
bit easier on the BMI system.
yeah, so then you would just go through and go to put like, I mean, as much information as you had
Yeah.
about the song, and then it'll most likely have it there if it's been published work.
So those PROs, that stands for Performing Rights Organization. So that should be a clue to you that we're talking about the right to perform the work publicly. All those entities do is administer those rights for different songs, different musical compositions. They're all versions of the same type of company. ASCAP, BMI, CSAC, PROs. It's alphabet soup. Sorry for that, but if you Google or you write down Performing Rights Organization or ASCAP or ASCAP ASCAP, just abbreviations. They all do the same thing. They administer the public performance rights. So what that means is the composers, the authors, the owner of that original musical composition right has entered into an agreement with one of those companies to say, take care of this part of my rights. And they grant them the right to then go out and license it to other people and give people a license to perform it publicly. So that's not what you're trying to do. You're trying to cover, but you use that entity, you use that system to find the people that you need to get permission. It's just a really good source of information. Different people use different things. Some people use the Copyright Office more because you can search registrations in the Copyright Office. I just think it's clunky. It is clunky. It's clunkier than these systems are.
Right, and this will give you like the person that their go-to contact for dealing with all this is, so that way you're not having to like hunt down.
Yeah.
You know, the person that actually composed it, because they've probably hired someone to administer that for them.
You're still gonna, what you're gonna find is, composer names and publisher names. And publishers are people who a composer has given the right to administer even more than just their public performance right, other things too. So they can grant licenses and stuff like that. Like I get requests from publishers all the time for, hey, these people have requested to do this. Does the client want to do that? So that they work through the publisher. So you're using that database to find it. You're still going to be Googling how to get in touch with them. Sometimes there's emails in there, right? But and you start to build up a little bit of a network of who you call if it's a universal song or an Atlantic song, but that takes time. You want to be doing all this stuff, but you want to be making music, right? So you want to find ways to do it more efficiently, or build your team of people around you that can do do things for you, outsource things, like outsource the parts that you can't. Whatever you can afford to outsource things to me, do it, because we're not good songwriters. Like, you should spend your time being songwriters. Let me do this stuff, or like Harry, but even better. You know, like outsource it to it's just like you do, you know, do you always fix everything that breaks on your own car? Probably not, maybe some of you, but no, probably not. Outsource that to someone who's an expert at that. That's my advice. So do that one as soon as you can, as soon as you need it.
You have here, every artist should be insured. Who do we go through to be insured, and how much insurance, and what are we insuring ourselves for?
That's a great question. So I didn't even talk about what BLA is. So let me, in the process of answering that question, talk to you a little bit about another resource. I bragged about giving them resources when we were talking about it, put this thing together. The Volunteer Lawyers and Accountants for the Art. It's an organization in St. Louis. There are similar ones all over the country, cities all over the country. And it's exactly what it sounds. It's lawyers and accountants who volunteer to help people in the arts with their questions and with their sometimes problems. They're not always experts in the subject matter of, like, in this instance, the music business, but they might be people who will help you with incorporating your business, like just getting it set up as an LLC. And that's something we do too, but a lot of different types of lawyers do that. You don't have to be a music lawyer to do that. You don't have to be a film TV lawyer to do that. Getting a license from the city, you might need a business license just to operate your studio in the city. They might have to be able to help you do that. There's a lot of help with things around taxes and setting up your business so that you know what taxes to pay and when to pay and all that stuff. They have a lot of good accounts that help with that. So if you have, utilizing BLAA is a good way, especially when you're starting your business or when you're changing it a little bit and doing a new thing. Try to utilize things like this. You contact them, you apply. If there's income questions, but we try to be really liberal about whether we're able to help people based on their income or not. But I've been on the board of BLAA for a long time. There's lots of lawyers and accountants all over the city that help us out. And so this is a referral system. So you go to BLAA and they help find a lawyer and accountant that can help with your particular question.
Yeah, I've volunteered and done many clients to the VLA, which has been kind of how I got set up with Gary and how we got like to do this today too. So they put this on for us.
Yeah. So it's a really good organization. And they have a lot of other things like this, like pamphlets and information and stuff like this too. And they do mention some like practical things like having insurance. To be honest, I don't know based on what type of artist you are, whether you get insurance for that and what you need that for. It's really important when you're doing any kind of physical operation. A TV set, even a recording studio, places where people are doing things with equipment, it can be dangerous, people get hurt, things get broken. That's certainly more important. I wouldn't say it's unimportant because this is important, right? But it's not probably as important for, a poetry setting because you don't have a physical environment that you're bringing people into and things like that. But that is a question, if, getting insured, like that's something that, like, do you have someone who can help me evaluate what insurance I need for my business? It's a good BLAA question. So, yeah, but I think I gave every one of these. This is a really good resource to use as well. Before I forget, there are a couple of other things coming up this, next couple of weeks that are educational. BLAA is involved in another one. Not next week, but the week after, whatever, Thursday and Friday or the week after that. It's related to the Music at the Intersection Festival that's happening in 2 weekends. They're having some panels. One day is at Webster University on Thursday, and one day is down in Grand Center at a place called Zach. And there's different topics. There are not a lot of legal topics actually, but they're arts related topics and arts and business and culture related topics. That's looks like it could be pretty educational. I spoke there last year, and kind of a similar Q&A kind of thing. You can go to learn more about the arts and the business of music and other art forms too. So, and then did you know about some other events that were happening still that you could tell people about?
Now that think it's the Banger Park, Forest Library, they're having some sort of a block party.
Okay.
I think it's September first, maybe.
Okay.
Yeah,
Yeah.
This Friday.
they're gonna have food trucks and all that kind of thing,
Yeah,
so it's
okay.
gonna be really nice.
Nice.
Big, one of the largest events we've done at Forest Valley, so it'll be a lot of fun.
Cool.
Yeah. And this Wednesday, if you have any interest in rap music, also at Forest Valley, we are talking about the evolution of rap music, most important songs from 1970 until 2012.
Yeah.
Wow.
Will also be a listening party, so I have to keep the door closed.
Oh, yeah.
That's awesome. Are you presenting that?
That is gonna be this Wednesday at 7 p.m. at Forest Valley.
At
Yes,
Forest
I
Valley?
am presenting it.
That's awesome.
Yeah, I'm very excited. It's at
You said what
7
time?
p.m. 7.
7, okay.
Yeah.
That's fine.
Yeah, it'll be downstairs in the big meeting room.
And the third trip was
September 1st, they are having the hip hop block party at Forest Valley as well.
It's still the same time.
What's that one? Yeah, can you look that up? I know it's in the afternoon because all the branches.
No, I'm talking about close to Friday.
Before that.
I think she's looking at-
5:30.
Oh,
5:30.
so they're doing it right. Okay, so 5:30 to 7:30 this Friday is the hip hop block party. So they're doing it after the branch closes, which is.
Good.
I appreciate the information you've given, this helps me get things organized, well, yeah, because they said after you publish, you really don't need to turn it into the Library of Congress, but I'd like to have it in the library.
Yeah. It's an enhancement.
Yeah.
Giving me some things to think about. Thank you.
Good, that's what we're here for. Thanks for coming and listening and asking questions. Yeah, it's been fun. We'll hang out a little bit, get a bit tour, like questions or whatever, and, I'm sorry, let's go from there.
Alright, so we're gonna wrap up with the recording and Zoom and everything.